All right. So, good evening, everyone. Welcome to the Development Review Board annual training. So, first of all, let's do a roll call. Evan Thompson,
Present.
Brent Hartman,
Present.
Deborah Neal Morrissey,
Present.
Barbara Vandermeer,
Present.
Rick Kane,
Present.
Rebecca Herring,
Present.
Jamie Bell. Thank you, everyone. So next item on our today's schedule is the presentation by our city attorney.
Well, good evening, everybody. I guess I'll start. Can everybody hear me okay online?
Yep.
Yeah.
Sounds
okay.
good.
Well, great. Well, my name is Sean McDermott. I'm a senior assistant city attorney. I know several of you have, I think, heard this presentation before, so, I'll try not to make it overly boring, and please feel free if you have any questions throughout, feel free to stop me and ask me anything. But this is basically just a training that I go around to do with our various boards, just to give kind of the 101 of how to be a board member, and just like some of the high level things you just kind of need to remember as you operate as a development review board. And so there was a slideshow, but I don't know if you have that pulled up. There it is. Okay. Yeah, so you can switch to the next one if you don't mind. And so this is just a high level overview, just kind of what we'll be touching on tonight. Shouldn't be very long, but again, happy to answer any questions you have. I'll just say, just from this page right here, there's the first four bullet points all city boards have to deal with. Okay, in all most any public officers, it's like staff as well. It's that last one that only select boards, and you guys are one of those, the Development Review Board, where you actually are adjudicating rights. And so there's a constitutional right that everybody knows you can't deprive life, liberty, or property without the due process of law. And so because of that, when there's certain decision makers that are deciding any of those rights, in this case property rights, there are certain constitutional due process standards that do apply, and you have to be real careful about how you orchestrate going about adjudicating those rights and holding your hearings. And so this board, you have the full gamut, in other words, of stuff to kind of to review, whereas some boards strictly just act in an advisory role, and they just come up with whatever their opinion is to generally pass on to the city commission, and they don't have to worry about all that kind of particular stuff at the end. But yeah, with that, we'll switch to. We don't have to go through this, but this is just where what the Development Review Board is, starting all the way up with the 10th Amendment to the Constitution, and it flows all the way down through the federalism system to the state of Florida, all the way to the city of Gainesville. And lastly, the Land Development Code is what forms the Development Review Board, when the City Commission adopted certain provisions that form the Development Review Board. And within that code, it specifically specifies the authority and the powers that this board has. And I only mention that because that's always square one of like, where does our authority end? Some boards, and this is not one of them, but some boards sometimes get a little outside of their lane, or they have trouble kind of knowing like, what's our mission again? And so yours is to review developments, and there's other things that are laid out in that section of the code, Land Development Code. So, all right, so getting into you'll hear stuff. The state of Florida, there's the open government laws, and those together make up the Sunshine Law and the Public Records Law. So any board of the city has to comply with these, and they're really easy enough. The Sunshine Law, this is it right here. Any meeting of a public board or commission has to be open to the public. Notice has to be given to the public, and minutes have to be taken. The 1, 2, and 3, I would just say board members, you don't even have to really worry about that. City staff kind of takes care of, scheduling your meetings and make sure they're open to the public and notice and taking minutes. The biggest thing for you, any board members, to remember in the back of your mind is that the Sunshine Law applies when you actually have a meeting between 2 or more board members. So that's the key thing to focus in on. And the next slide will kind of go into that. this is what a meeting is as defined in state law. It's any gathering, formal or casual. Not so it can be out in Publix. It can be, in a neighborhood association meeting. It could be at a dinner, anywhere. But any formal or casual gathering where there's 2 or more members from the same board. So the Sunshine Law only applies to the board, you board members, vis-a-vis yourselves. So it doesn't apply to staff or anybody else, spouses or whatever. So it's just each other. And when there's 2 or more of you that get together at any time, it can be virtually, in person, whatever. And the key thing is to discuss any matter that foreseeably can come before the Development Review Board. That's when the law requires that those discussions have to be in the open, where the public is invited. All to say, so, it's perfectly acceptable to be, friends outside of the Development Review Board, to see each other and to talk. You just don't want to talk about stuff that has anything to do with the Development Review Board, because that is what's going to trip the Sunshine Law, meaning it has to be held in public. So that's it. That's the Sunshine Law. That's much more complicated with people who have a lot of circles that kind of overlap. A lot of our elected officials who serve in different capacities, and they overlap with each other. And it can be, I don't want to say common, but it can be a temptation where they have discussions that are like, oh, wait, we can't do that. That's business that we have to do with that board. So that's it. That's the Sunshine Law. Public records is also, easy stuff. It's just it's just a statutory and Florida constitutional right that says the public has right to access all materials, and the keywords are highlighted, that are made or received by you as board members, that's used to perpetuate, communicate, or formalize any knowledge in connection with official business. So easy way to remember it is just like any type of materials. It can be papers, it could be voicemails, it can be text messages. It doesn't matter if it's on the city email account or your Gmail account. It doesn't matter personal phone or city phone. Although I don't think board members get city phones. It doesn't matter where it happens. It doesn't matter what the data is, as long as there's some kind of data recorded that you made or received. So keep that in mind. If a member of the public emails you something and you didn't even want it, but it's just like you got it because they gave it to you. That's a public record. And if it's a public record, what that means is that the city has to keep it for a certain amount of years that the state of Florida designates. And so you don't want to throw it away. That's basically it. So easy, practical thing to do is like any type of materials you get in the role of your board as a board member, just make sure the staff gets a copy of it or gets that document or whatever it is, so we can keep it. Okay. A couple practical tips on that is the state of Florida does say if there's like a duplicate, if the record is like a duplicate where there's like some kind of master copy that the city does have and can keep in accordance with the law, that you can throw out the duplicate or get rid of it once its value has been lost to you. What that means in layman's terms is like, say you have a meeting and you get a bunch of handouts, but staff has the master copy that printed out the handouts. But like once you're done the meeting, you can recycle it or do whatever you want with it because staff has the copy. But if it's like, you're at a meeting and a member of the public is giving you something that the city doesn't otherwise have, that's where you want to be careful and make sure the city has it. So that's easy enough too. Sunshine Law, public records, pretty basic stuff. All right. And that's just kind of some of the liability that's involved. We don't have to go into that, but there can be consequences, particularly when folks violate the open government laws intentionally. It can get kind of dicey. All right. The third big area is just ethics law. This is also pretty kind of commonsensical stuff. And I'll just say ethics, as opposed to, if you ever have questions about the public records or the Sunshine Law, like my office will happily answer it, with a definite answer. Issues of ethics, however, are the board member's own personal responsibility. And so I'll be happy to weigh in of like, I think you're probably okay voting for this, or you probably shouldn't do this. But you always want to, if there's a question in your mind at all, you always want to call the Florida Commission on Ethics, and the number is right there. That hotline is like really easy to use. They always answer. They can give you answers really quickly, and they give you a kind of a binding opinion as opposed to that we can't. And so just keep that in mind with ethics. And then the next couple slides we'll hit some of the high points on the ethics laws that you might run into. The law of ethics in the state of Florida basically can be broken down into two components. There's like certain disclosures that board members have to make, which are kind of listed up there, and then there's certain behavioral requirements. What's proper behavior as a board member. So as far as the disclosures, most boards actually don't have to do this. It's only against certain heightened boards, and the DRB is one of those because you adjudicate land rights. That the state of Florida does require these heightened disclosures, and what they include primarily are these three that are listed. The first one is the limited financial disclosure. That's done annually, and as opposed to the elected officials, they have to disclose a lot more in depth about their assets and whatnot. But this is I think it's 1 or 2 pages, pretty easy to do. It has to be done annually, and it's ultimately gets turned into the supervisor of elections, Kim Barton, and staff can help coordinate that, when that happens and how to do that. But so there's that annual limited financial disclosure, and then the other two are just kind of on a case-by-case basis. Quarterly client disclosure, if you are a partner or associate of your firm, represent a client for compensation before the city. So you'll know if that happens. Sometimes, like our historic preservation board, I know they say have some historic architects who represent folks before the city, that like who are doing stuff with their houses or whatever. And so every once in a while, some of those board members will have to disclose that these are my clients. So that's done quarterly. The other one's a quarterly gift disclosure. If you receive a gift more than $100 from folks who aren't relatives, and the gift isn't just business related with your firm. So, all right, and then the next one we'll go over like the behavioral standards, and this is, like I said, it's all kind of basic common sense you can imagine. But to serve as a board member, you can't be employed with or have a contract with a business or agency that is regulated or doing business with the city, or when that relationship poses a frequently recurring conflict. So that's just the basic situation of if you're a board member who does something specific in the city, you can't contract with the city. Like we can't do business together and you be a board member. That's just a natural conflict. The second one's even more common sense. You can't corruptly use your position in any way, or any info that's not available to the public. You can't use in any secretive way. And then also gifts. That's a big thing in Florida ethics. You can't solicit or accept anything of value based on understanding that you're gonna vote a certain way. Of course, like that's a no-brainer. And then you can't otherwise accept a gift again worth more than $100 from anyone that's lobbied the city in the past 12 months. So yeah, that's the ethics. Oh, and of course, this is the one, probably the most important one you might run into, is you have to, sometimes you'll have a voting conflict that you have to declare and then abstain from voting. Okay, so otherwise in the state of Florida, per state law, you're required to vote. So board members, you can't just, you don't have the luxury. Yeah, you can't just I'm politically against this, or I just don't want to wade into the heat, so I'm gonna not vote. Like folks, I think Congress can do that otherwise. But in the state of Florida, you have to vote, whether it's easy or not. And so the only 2 exceptions to that are the one that's more common is when you have a voting conflict, which we'll get into in the next slide, or the other one is when you have a bias, that's very rare, and that gets into the due process interest when you're doing adjudicating a quasi-judicial matter, which we'll get into that at the end. So getting to voting conflicts, which is the next slide. This is when you have a voting conflict. So there's a matter before the DRB that, depending on the outcome of the vote, it could result in a special private gain or loss to you, a relative, a business associate, or a principal by whom you're retained. And then those are the definitions of a relative and a principal. So you can see the relative, I always point that out. The definition for relative is pretty narrow. It doesn't just have like first cousins, for instance. So if you have a first cousin that has some kind of interest in property or something, per the law, you don't have to declare a conflict. So that's when you have a voting conflict, and what that means. So if you have a voting conflict, that means you have to disclose it at the meeting. That's the first thing. You can't vote on the matter, but you are able to discuss it. You're still able to take part in the discussion. You just can't ultimately vote on it. And I think the next slide says, so that's how you disclose the vote. There's a certain form. Again, the staff can help you out, but you do it in writing, and then at that meeting you also declare it. So that's it. That's like sunshine law, public records, and ethics. And then this gets into the last bit, which I think you'll deal with the most, which is how to hold a quasi judicial hearing. Okay, and like it says here, local governments generally, undergo either legislative decisions or quasi-judicial. I think you get your board will. I think there's some matters that are legislative. Typical example is, you can correct me if I'm wrong, but if there's like some type of some issue that you just want to give advice to the commission about. I can't think of any like that have come before you off the top of my head, but say there's just something that you're not adjudicating any private property rights or whatever. You just want to give advice to the commission. Like I think you guys, you all submitted a letter to the commission. Like that's what I was trying to think of. Like several, months ago.
Yeah.
Right. So that's a legislative item. So that's just acting in purely legislative fashion, where you make a recommendation or have an opinion that you want to submit to the commission. That's simple. There's no due process requirements for that. Okay, so you don't have to. There's no bells and whistles that you have to pull out. It's just really easy to do. The quasi judicial is the. I think that's going to be predominantly what this board does, and that's the definition of what it is. But it's basically adjudicating property rights, and so you're applying law that's already been established by the city commission in this case, and you are applying it to a private applicant who wants to do something with their property. Okay, and so if that's the case, that's when all the bells and whistles and due process come out, and then that which gets into the next slide here. And these are kind of the broad parameters of what state law requires for those. But that's when you have a hearing. So it's officially a hearing. So that's why it's quasi judicial. It's kind of court-like, okay? And you're kind of the judges. So it's not as stringent as across the street in the 8th Judicial Circuit, but there's still some definite requirements that apply. And the main one being the procedural due process, and that requires adequate prior notice to all affected parties, a fair opportunity to be heard, and to present evidence, and to cross-examine any witnesses.
Can I make a comment here?
Yeah.
This isn't clear on the formal versus semi-formal approach.
Yeah.
So we do have two very different approaches.
Right.
The true quasi-judicial is formal, where you do have witnesses, and it is very formal, versus the non-formal, which is, I would say, I haven't seen a formal one probably in 3 or 4 years.
Right. That's right. So
They're different.
They're different just in the sense that we made them different. The distinction between formal and non-formal or informal is just a local creation that the city created, purely for matters of like simplicity for our boards.
Yeah.
And what I mean.
Formal is normally when someone is pretty upset about a specific topic, and they basically are bringing in a lawyer frequently and want a very defined presentation and decision.
Yeah.
And it's very similar, but it is not the same.
No, they're not orchestrated. The process will look different in your meetings, but what's important to know is all the legal requirements,
The outcomes are the
all
same.
the criteria, all the legal rights that are involved are the exact same.
Yeah.
So the reason we make a distinction between formal and informal is just because I would say 95% of the applications that our land rights boards get are so routine, nobody really cares about them, there's no controversy. And so just for matters to make it expedient and to not kind of be overly burdensome with all these like in the weeds, like bells and whistles, we allow, we put it kind of, I don't want to say the burden, but we leave it up to the affected parties to declare that. Do you want to kind of forego, like, because it's their rights, right? So it's like, do you want to forego all this extra process and just kind of quickly do an informal hearing, or do you want to, avail yourselves of all the rights you have and do a formal hearing? And you're right. Practically speaking, it's when folks, there's some kind of controversy going on that folks want to use the formal, and rightfully so, because they want it to be longer and more deliberative and kind of, like I said, all the bells and whistles. And
So it's nice and helps stop, but because there's more discussion, you can actually have more airing on both sides. Or if the board has concerns, there's more ability to ask questions at the level of the topic and clear to the board.
Yeah, and you still have, as the board, you have all those rights to like ask questions and deliberate even on the formal. The formals just, they have a tendency, well, like tomorrow night we're having, they're not quasi-judicial, but it's a very controversial item. And so because of that, it has the tendency to suck the air out of the room and everybody's on edge, especially when there's lawyers involved. And so, yes, it can stifle kind of the free-flowing discussion. So yes, informal hearings they're great. And like most of them are that way just because they're kind of run of the mill. And so, but all the same requirements here apply. So the procedural due process, and the essential requirements of correct law have to be applied. And I'll just get into that briefly. Like what that means is like that is the key kind of requirement in state law that keeps boards in their lane, so to speak. And what I mean by that is, there can be, like when you're making your decisions as a development review board, you have to make them very tightly based on the review criteria that are established for the board in our land development code. So, for any development application, there's specific review criteria that the board has to use to make the decision. And you can't kind of get out of that lane, or just it can become illegal, and the decision can be struck. So what I mean by that is, like, if you have, say, a special use, or just one of the developments that are going to be coming your way, I think, soon because of the code change. So you have one coming. You wouldn't make the decision based on just like, do I like this development, or do I like this person, or do I wish it looked a little different? Just kind of your own whims. Like the board doesn't have that discretion. You have to very literally apply the development criteria, which is predominantly our land development code. What you're looking to see is like, does this development meet the criteria in our land development code? Which, by the way, is not an easy undertaking because our land development code is the thickest document in the city. and so does it meet this thick document? Well, good. I don't want to say good luck, because it's like that's what you have staff to help you out. So staff are like the experts in all the different areas, like whether it's public works, GRU, transportation, planning. They're all kind of the substantive experts that know that document, and they can kind of steer you to and they might be able to point out that largely it meets everything, but what you really might want to dig into are like these three things. So they'll kind of help you get to the chase, But nonetheless, you really want to stick to the essential requirements of law, like what the criteria are, without wading into your own opinions. Sometimes that's difficult as humans, but that's what we have to do as the judge for these development applications. And the last one is just competent substantial evidence. So what that means is like the way the hearing, typical way a hearing works per state law is, it's somebody asking to do something that the code allows for if certain conditions are met. Like say you have to meet the requirements of the land development code. So somebody approaches your board and is asking for that. It's that property owner or developer, whoever it is, it's their burden to show initially that, look, these are the requirements of the code. I'm going to present evidence that my application meets it, okay? And they present that evidence through a variety of ways, like submission of reports that'll be in your backup. They'll make a presentation there and talk about it, a whole host of things. But so they do that. This is where it's like a court case. They present their case first, present the evidence why they need it, and then it goes to basically anybody who opposes it, or sometimes staff to point things out that kind of weigh against what the developer or the owner just said. Okay, so it kind of contradicts it. And then so there's evidence presented. That's what competent substantial evidence is. It's just you don't get a development right just because you ask for it. You got to present evidence. It's kind of like a court hearing in that sense. And conversely, if the application is going to be denied, there has to be evidence of why that is too. So like if the developer gets up there and presents evidence of why their application meets the land development code, and the board just wants a motion to deny, that's a recipe for disaster, because there has to be some type of evidence and reasoning of why it's going to be denied, in particular in strict conformity with the review criteria that you're using. So you can't just deny in a whim. It has to be denied on like evidence presented of why they didn't meet their burden. They failed to meet some requirement of the code. Okay. The development review board, when you are deciding development applications, you can do one of three things. You can either approve it because the developer or owner met their burden and everything, all the requirements are met, so you just approve what they're asking for. The second thing is you can deny it. If there was like evidence of why, to support the denial and the reasoning is there, you can deny it. A third thing is you can approve it with conditions. Okay, and that's sometimes for the more complicated ones, that's kind of what ends up happening. And what I mean by that is like if there was an application, they present it, and say they met almost the entire code, but there was one part that staff mentioned, like, well, they're supposed to have a sidewalk, connected to the neighboring property or something like that, and they didn't have that. And so staff kind of presents evidence, remember, that why they didn't meet that. You could say, well, rather than just deny this whole thing, we'll approve it with the condition that you put that sidewalk in. Okay. So, but that has to be based on a requirement. You can't go at all afield from, again, the review criteria. So in other words, the conditions can't be just kind of something you would like to see. Like, we'll approve it on the condition that your building's not ugly or something, like that would be an impermissible condition, and there's a whole body of case law that why we can't do that. So those are these are kind of, again, the standards for quasi judicial hearings. The next slide, I think, just talks about, this is a key point to remember. Okay, so as essentially judges for whatever matters before you, you have to be unbiased. Like, this is long-standing common law in any state. And the biggest one here that I'll say is that third bullet point there. But the biggest thing to keep in mind, and this is maybe the most difficult thing to remember, but you don't want to have ex parte communications. And what that means is, so any quasi judicial matter that's coming before you or was before you, you as sitting again as the judges, essentially, you cannot have discussions outside of the hearing with any actual party to the hearing. Okay, so why that gets difficult is because maybe, unlike clean, say, slip and fall cases before a court, where there's like, the company that didn't clean their floor and the person that slipped, like, they're the two parties. there's like a definite, okay, the judge can't talk to those two, right? It's easy. Here, with land use cases, affected parties can be pretty broad. And as a matter of right, the city of Gainesville grants affected party status to anybody that lives within 400 feet of whatever property you're discussing. So already, that's a lot of affected parties. And then, as a matter of right, the city grants affected party status conditionally, if they ask for it, to anybody outside of that 400-foot boundary. If they have a little burden. They have to show that the application can affect them to like a degree that's different than just the general public. Okay, but if that's the case, they would be affected parties too. And my point here is it can be a broad amount of people, and it's going to be hard for you to determine, like when you're in Publix and you have some controversial development come, you're meeting next week, and you're in Publix and somebody comes up like, well, you're not going to vote yes for that, whatever, like you have to be careful because you can't have ex-party communications or the whole decision is prejudiced, which we don't ever want to get into. So that's why with quasi-judicial matters, you want to be real careful and just not talk to folks outside. Okay. Now again, remember it is, although it's a potentially broad class of affected parties, that doesn't include staff. So you can of course talk to staff about whatever's before you. It most likely doesn't include your friends or family, unless they happen to live. Maybe they are. But generally, you can go home and talk about it. You can so you can still talk to a lot of people. It's not, but you just want to be very careful to not talk to anybody who could potentially be a party. So, yeah. And if he does happen to, because sometimes, you'll be in Publix and somebody will just run up to you and start talking to you about it. You want to just shut it down as quick as you can. And then at the meeting, by law, you have to disclose it. So you have to, I did talk to such and such, and you're supposed to say the substance of what they mentioned too, because the whole reasoning behind it is everything that's supposed to be considered and discussed is supposed to happen at that hearing that's open to all parties, so everybody can take part. So nothing happening kind of behind closed doors. So no ex-party communications, remember that. And that's like maybe the biggest thing to remember with quasi-judicial, besides kind of the bells and whistles of how to do a quasi-judicial hearing. The biggest thing to remember is to not talk to anybody who could potentially be a party.
Sean, can I ask a question?
Yeah, absolutely.
So on that topic, how long, can you discuss it after a decision's been made? Say you run into that same person, a month later and they talk about it. Can you discuss it then?
Yeah, that's a great question that I get pretty often. And it's hard to give a definite answer. And the reason is because decisions can be appealed, right? And so there could, the best practice in the state of Florida is that until like the appellate window has passed, whatever that may be, and for so I would say at least 30 days, I would still refrain from talking to anybody. Okay. But if it starts going past that, we're talking like 6 months out or whatever, like 3 months out even, like I think that would be permissible.
Gotcha. Thanks.
Yeah, so that's it. I know, just to keep in mind, I think starting October, you're going to start getting more development applications because of the change that the city commission made. And I pulled up and you probably have seen it before, I'm sure, but I just pulled up your review criteria. So like anytime you get all these quasi-judicial hearings, what the Land Development Code says is your criteria is that it is two things. One is that the application has to be consistent with the City of Gainesville's comprehensive plan. And two is that it has to be consistent and meet all the requirements of the Land Development Code. So that's where I said those are two big documents, and what you're looking for is that it meets all that. So, yeah, so to the extent that you can, peruse our Land Development Code and comprehensive plan to kind of get familiar with some at least like a high level understanding of what it requires and what it, the conditions it imposes, that would help, in your role as making decisions on developments. But yeah, if ever there's a formal hearing, if it's ever controversial or something really heated, like I'll be there. So like to help everything kind of run smoothly. And otherwise, if you ever have questions about anything, I'm happy to answer.
I have a question. Is there usually an attorney at the meetings or only once?
Only as needed, because we have so many boards. And I tried to attend all of them back in the day, but if there's nothing controversial, my job is kind of boring because I just sit there and everything runs smoothly. If you have any questions or want me to be there for any reason, I'll be happy to be there. And then if there ever is a formal hearing because somebody requested it, I'll be there. So yeah. So that's really it. Is there any questions or? You guys are easy.
I actually have a question for one of the board members. I think it would be helpful if you could explain a little bit more about the changes upcoming in October.
Oh, yeah. So the change the change was to off the top of my head. So the way that for development applications in the city of Gainesville, they get classified, I think, in one of 3 classifications. You might know better than me. I can look it up quickly, but I think it's like major development applications, or maybe minor, major,
intermediate,
and intermediate. Yeah, there we go. That makes sense. Minor, intermediate, major. And they use and the land development code assigns depending on which that classification is, and it's all according to size. So if it's commercial, it's like how many square foot, the square footage of the commercial development. If it's residential, I think it's like how many units, the more units, that's what puts it into one of those 3 classifications. And the land development code assigns for each of those classifications, how the decision is made to approve the development application. And I think what was changed is oh yeah, here it is. So what they changed was where all developments, even major ones, would be made administratively, so just by city staff. I think it's just major now, right? Not intermediate.
Just major.
So just major now will, rather than being the decision being made administratively by city staff, those are what's going to be coming to the development review board. And so those are right here. Any residential development that has 51 or more multi-family dwelling units. Okay, so condos or apartment complexes that have 51 or more units, those developments will come in before you. So if it's a development with 45 dwelling units, that still will be made by staff. So that's for residential. Non-residential is new construction or expansions over 50,000 square feet. So those big ones will now come to this board for. And I want to say, because when the commission made that decision, we looked, just out of curiosity, how many roughly that would be. And I want to say in a year's time, it was about 20. 25? Was that what? Yeah. Okay.
Yeah, it would be a big change. We used to do this about 4 years ago, and then they took them out.
Yeah.
So, and it's much more, especially large developments, much more coming out of it during that time.
Right. Yeah. The hot development market.
Yeah. So it will be a change. But as long as it'll be fairly quickly, as long as they are well presented. There's
Right.
nothing bizarre. But usually it's a matter of just checking on a few little details that the board would look at.
Uh-huh. In the best form, that's exactly what it is. The problem with developments, this is just nothing legal, but just practical advice.
Yeah.
New developments, it can generate some heated opinions.
Oh, yeah.
So there's nothing that will stir people up more, I find, locally than a new development going in somewhere near them. And now as decision makers, you could be in the line of fire for taking some of that heat, right? And what's hard is the concerns often that people raise could be very valid concerns on a human level, but they're not part of the code. And so you have this sympathy of just yeah, I agree that development's ugly too, or I wish it did this or that. but if they have the right to do it, they have the right to do it. And so that's what you have to be careful with, is kind of wading through the hyperbole or high emotion and just like opinions that really aren't grounded in the code. You have to be able to wade through that and really to the critical issues of how you have to make your decision by it.
But you did give a conversation at times you can compromise. Classic case, which is put in the letter that you went to the conversation, was a 3.5-story apartment building going into a University Park neighborhood right next to a house. And you would literally have somebody looking through their windows of that 3rd floor into the room. And so the developer, after discussion, said it was fine, they would put no windows by the house. That's the kind of thing that I asked to have these discussions brought back, because there are times that you actually can negotiate some compromises if the developer is willing to do it.
Yeah, absolutely.
So the other question I had in regards to this is that we reviewed the Seminary Lane development, and it was presented as affordable housing. And then I went back and looked at the records, and it went through like 3 different ownerships before it was actually built. It was completely changed. So how does that work? How do you have a development come in, you look at it, you give them the parameters, you approve it, and then it goes for several years through all these changes, and it's going to be a horse of a different color by the end. How does that work?
Well, I mean, a couple things, like, developments, like the city doesn't regulate ownership. So, you mentioned ownership changing, like that happens, and I don't do,
I understand
I'm a
that.
city attorney, but I don't do the development world. But I do know that that's pretty common, where somebody will buy it,
Yeah,
they'll get
I
approvals, and
understand.
they'll sell it to somebody else.
Yep.
So, so that certainly can change.
But the actual parameters,
That doesn't change. So anything that's within the city's kind of jurisdiction that the city decides, conditions on a development or whatever the case may be.
well, they were different by the time it was built. I'll just put it that way. They
Yeah, I don't know
were,
specifically.
I'd have to go back and look at the original paperwork, but it really was presented very differently than what actually happened.
Well,
So
the Seminary Lane.
That's why Seminary Lane became such a hot issue.
Well, Seminary, that became hot for lots of reasons.
Yes, it
but
did.
but
Yes, it did.
but as far as the affordable housing, and this is just off the top of my head, but whatever was approved, and I do remember there is some requirement that they have to put in. There's a certain number of affordable units.
Yes.
And that's still a requirement. That's just coming on like their 2nd phase. That's like it's like the what is that? The northeast corner of, was it 5th and 12th? Like that lot. That's what they're going to develop into. I think it looks, in vague memory, I think it's like row homes almost.
You're doing pretty good. It's causing so many iterations of it, man.
Yeah. So that's still a requirement. It's just that's just a phased development. So right now they're building 1 phase. They're going to do that after, and then a park on the.
And it's unfortunate that's never come out in all the discussions.
Yeah.
It really has never come out. This is out of line for this discussion, and that's why I push to have more communication on the board between the developer and the neighborhood, because a lot of these, not all of them by any means, but it can be reduced somewhat if there's more available communication before it goes up, because it just turns into a fireball.
Yeah. No. Yeah, you're right. I think the public discourse at the hearings do have an opportunity to.
I mean, it feels like a waste of time. And I talked to the city commission meeting when they were talking about it months ago, and they were just talking about how much time, how more expensive it is. Nah.
Yeah, there's different policies.
That dismisses the whole point, It's like, okay, fine.
The last thing just jogged my memory, it's worth just mentioning, of course your criteria are the comprehensive plan and the land development code, right?
Yes.
And but I will say, even within the say within the land development code, which Gainesville largely the kind of a form-based code it's called.
Yes.
So that means there's a lot of criteria that you'll find are kind of robotic. You won't have much discretion over. Like if somebody's allowed, say, 7 stories and their development they're trying to do 6 stories, there's no discretion there. It's like they're allowed to do that, right? But there are some criteria that do benefit from some human kind of, they're more what's the word I'm looking for? It's more not necessarily subjective, but there's some interpretation that goes into.
Yeah,
Like-
more friendliness between the neighborhoods and the development.
Yeah.
It really helps to have a discourse. It's human nature to have more of a sense of understanding. Even if you end up not happy, if you're heard.
Yeah.
A lot of times people are heard, it makes a big difference. Even if they're not getting what they want, if they feel like they've been heard, which is
Absolutely.
part of the reason that I push to have this discussion.
Yeah, that's a good point. So yeah, so just remember those, like any of the criteria that are some discretionary, that's where you can really kind of hone in on and say, you know, and require, make conditions for the developer.
And we talk about it with the developers. It's not like we're making them doing it. I mean, they come in and they want their development to be like. They're not there trying to push it down people's throats. They really do want it to be like. So if you can sort of help people work that together so there's a little bit of give, then I think that's
Developers and attorneys, you know, nobody likes them.
well, you're paying me compensation. It's not your fault.
Oh, no. So, yeah, so no more questions, that was it. Thank you all. Yeah.
Thank you everyone for participating in today's training, and thank you, Sean, for the wonderful presentation.
Absolutely, my pleasure.
Bye, guys.
Bye.
People.
Thank you. That was great.
Yeah,
Very informative.
thank you.